Hey, good morning. Hi, Prateek.
Hi, good morning, Amir.
Welcome to the talk. Uh, so Prateek Sarkar is a practicing advocate. He practices in insolvency-related matters. And today we're going to talk about the role of IBBI, especially vis-a-vis resolution professionals and the various disciplinary proceedings that have been taking place against them. So, Prateek, you want to point out any particular issue that you want to talk about?
Yes, what I'm trying to indicate is that by going through the order, one comes to a conclusion that at times the order is traveling beyond the contours of IBC. And at times it is giving up findings where the noticee has no occasion to challenge that finding. Now, for example, if you are holding something as a ground to suspend someone, that ground is not indicated to the noticee, to the RP at the time of the disciplinary proceedings. And the
Right.
first time that RP comes to know, okay, this is the ground against me. I'm getting the information for the first time in my order of my suspension. Had this been the parameter of holding me guilty, had this been there at the show cause notice, I would have contested it. I would have highlighted the position under which a particular decision was taken. Now,
So I'm
if
going to
that is
So I'm
taken
going
away,
to interrupt you. Sorry,
yeah,
Prateek. So
yeah,
basically, what we're saying is here we are going to analyze an order that you feel vis-a-vis one person, one RP,
right,
IP rather, which has
right.
been taken, and it is a show cause notice which has been issued to him. So there is a certain procedure which has not been followed. Is that what you're trying to indicate?
Procedure as per IBBI norms, I'm not too sure because I'm not aware
Yes.
of the show cause notice.
Right.
I'm sure IBBI might have followed what is given in the regulations.
Hmm.
What I'm concerned of is that if there is something, if I'm holding you guilty of certain charge, let that charge and the ground for arriving at the charge that be intimated in its entirety.
Right.
If I'm not telling the grounds on which I'm holding you guilty for something, and the first time the RP comes to know about it in the order of that
Order itself.
suspension,
Yes.
the RP had never any opportunity to contest that.
Right.
So this is something that I am trying to highlight.
Okay. So let's talk
So
about.
yeah.
Yes.
So
Yes.
the first instance that I can see here, it is there in the para 12.4 of that order. If I have highlighted it, the advice given by the COC to engage a suspended director as industry expert has seemingly provided an unfair advantage to Mr. Vadva as a PRA. It is directed that the matter may be apprised to higher authorities of Bank of India for dereliction of duty by its representative. Now, whether there was an advantage, whether the COC was right, that is on the merits of the matter. I'm not contesting at this stage on that. But what I'm concerned of is that it is directed that the matter be apprised to higher authorities of Bank of India for dereliction of duty by its representatives. My question to IBBI is that whether those concerned authorities of Bank of India were privy to your to the material basis which you have arrived at that conclusion.
Right.
What prima facie I feel is the answer is no, because this show cause notice was directed to the conduct regarding the conduct of Mr. Vishal Jain. So if any proceedings might have taken place, and of course at this stage it is a question of ifs and buts, and nothing contrary is coming out of this order. But what I see that the show cause there was certain material prima facie observations against Mr. Vishal Jain. Basis that a show cause notice was issued. Basis that a disciplinary committee hearing might have taken place. And after, as a conclusion of that hearing, this order has been arrived at. Where in this entire picture the higher authorities of Bank of India, the authorities of Bank of India are involved? There is nothing. The only time, for the first time, they will come to know about such a finding is the moment any proceedings or any inquiry comes up against them
Yes.
from the internal structure of Bank of India. Now, what is it indicating? Now, if I establish that, look, there was no obligation on the COC or there was no restriction on the COC to act in a particular manner in which they acted, then they are helpless. And as a consequence, if there are certain tough decisions and quick decisions that are needed to be taken by COC members, this will start acting against them. Every COC member will start thinking that no, if I take a particular decision, even if it is not prohibited in law, then maybe I may face any proceedings, any inquiry. Which COC member or which banker will want to take that risk?
So for any case, what we are seeing in proceedings, most of the proceedings, is that when the members come for COC meetings, they
Right.
don't come with any kind of authority.
Exactly.
It will always go with e-voting because they always have to take it to the higher ups. And I think the sense of IBC is lost because I think somewhere there was a circular or a guideline sometime back saying that whoever is appointed must come with the necessary authority to take decisions.
Exactly.
So that is always lost and we are getting nowhere.
And unfortunately, this is adding to the problems. This
Well,
particular
yes, yes,
is
that's
adding to
true.
the
It's
problems.
only adding to the problem. So instead of trying to finish something which is supposed to be a summary proceeding,
Right.
try to finish something in 270 days max. We obviously have cases now which are pending for 3 years and 4 years, and there are resolution plans which are pending for approval for 2 and 3 years.
Exactly.
So,
Now, and add to this a hostile management of the corporate debtor.
oh yes,
The RP will need all the support possible from the COC to contest that. And the hostile management will be quite very quick in its actions.
so don't you feel that somehow in the entire proceedings in these 6-7 years that the IBC has been functioning, there is only one scapegoat, and that's the IP or the RP. Whatever is wrong is thanks to the RP. Whatever is right is, of course, everybody's
Exactly.
contribution.
That's something unfortunately RPs in India have to deal with. It's a
Yes.
very thankless job.
Oh, absolutely. So now coming to this order of yours that you were highlighting.
Yes.
So,
I have authored one article.
yes.
I'll share that article. Now, this is the finding of Honorable Patna High Court in the matter of Deepak Mahato versus State of Bihar.
Mhm.
And I have quoted the exact extracts. Lack of knowledge of legal principles leads to miscarriage of justice and unnecessary harassment to the parties to the litigation. Bias and prejudices, conjectures and surmises, and personal views contrary to the material on record have no place in court of law. Now, this is a settle or this is a practice. Unfortunately, reading the order of Shri Vishal Jain, and earlier I had authored an article analyzing the order of Mr. Yogesh Kumar Gupta.
Mhm.
I found that IBBI had traveled beyond the law, beyond the material. I'm not privy to that material, but certainly, yes, beyond the law. So today I'm analyzing the order passed in the Vishal Jain matter.
But why do you feel they have
Subsequently,
traveled? Yeah, why do you feel they have traveled beyond the law?
beyond the law, because the law says something and their finding is punishing for complying with that law.
Mhm.
Now, for example, if there is no requirement in law to remain present before the Honorable NCLT at the time of pronouncement of order, certainly I will fulfill my duty as a role of an RP to protect the asset. Now, and even if I park aside that, even if I'm spending time with my family, what's wrong in that? The law is very clear. The law is very clear that if an order is to be read, there is a certain procedure of my communication of that order. I am waiting for that procedure to get fulfilled, and hence I am not before the Honorable NCLT at the time of pronouncement of my order. What is wrong in it? And quite often we come across that the only the operative part of the order is pronounced in open court, whether the
Always.
whether the application is
It's
allowed,
just
whether the
yes,
application
that's
is
right.
not
There's
allowed.
nothing more to
Even if
it.
I make myself present there, I am not getting to know what are the contents of that order. So what purpose could have solved? The answer is nothing. And if someone is holding me guilty for that, certainly something is very seriously wrong.
See,
And that's the reason I find that IBBI has perhaps traveled beyond the statutory requirements of law in passing order against Shri Vishal
see
Jain.
what would have been important is that you come when the matter is being argued. That is when you need to be present, not
Exactly.
when everything is done. It's only a pronouncement. That's really not required.
Exactly.
Your advocate to come and represent you. So if that is one of the
Exactly.
points raised in this order, then I think it is surprising.
It is surprising, and unfortunately, it is going in conflict with the principles settled with the Honorable
Absolutely.
Bombay Court.
Absolutely.
So I'm getting to the contents of it.
Yes.
So I have shared the extracts. I've just extracted what only the grounds on which Sri Vishal Jain had been held guilty.
Mhm.
So first, referring to contravention 2, inclusion of claims of promoters without verification, the bracket, this is what the title was. I am skipping the part. I am reading para 4.2 of the 4.20 of that order. In the CIRP of a real estate project, as a part of ordinary prudence. Now, this word is very important. As a part of ordinary prudence, IRP stroke RP must examine RERA registration details and all the relevant documents in this regard after being appointed as IRP stroke RP. Mr. Jain has admitted that he has not examined Form B. This Form B is an important document with respect to RERA registration of a real estate project, which is a declaration by the promoter. The form be duly signed by one such landowner, Mr. Parshuram Patil, for the project Vadva Rhodesia in the capacity of a co-promoter. The landowners on affidavit have stated that they are co-promoters and the same has been uploaded in Maharashtra RERA website. As observed by the Honorable Adjudicating Authority in its order dated 8 September 2021. Moreover, in the 6th COC meeting, there was a specific query from a financial creditor, Bank of India, as to whether landowners can be considered as home buyers, and the RP relied on the basis of legal opinion that the landowners were treated as allotee or home buyers. Now, this part is very important. This part is indicating that the RP had not acted on his own volition in his own whims and fancies, but he has taken a legal opinion. He is basing his decisions on a legal opinion. And certainly the least that can be expected is that the advocate is highlighting a settled position of law to him.
Right.
And he's quite fair on that. So availing a legal opinion is not something that is prohibited in law.
True.
Now, going ahead, had the RP examined the RERA registration details of the CD, he would have come to know that the alleged 6 home buyers were actually landowners and co-promoter of the project and not the home buyers by any stretch of imagination. Had RP done proper due diligence in this regard, unnecessary litigation could have been avoided. If RP had any confusion in this regard, he could have very well approached adjudicating authority for guidance. Now, this is very important. My question to IBBI is that if there is any confusion in terms of the interpretation of law or how a situation is to be dealt as per law, which part of the regulation says that I have to go to adjudicating authority? As far as I'm aware,
You cannot. You cannot.
As far as I'm aware, adjudicating authority is a body which decides rights.
That's right. You cannot.
It cannot say that it is not an authority to give you any opinion.
That's very right. They've completely misunderstood this. So, I mean, NCLT is not going to guide the RP how he has to conduct his duty.
And recently,
what is it that he has to, allow and not allow? Unless an IA is filed, an application is filed specifically on a question of law, which requires some interpretation. Again, with case laws, that's a different story altogether. You can't ask NCLT to let me know what is to be done.
Exactly. And moreover, recently NCLT Chandigarh has very categorically stated that NCLT cannot go into the day-to-day functioning of the RP.
Absolutely not. It's not
And
required.
it should not. So this is something which is, I'm not too sure from where this is coming from in the order and what transpired in the mind of IBBI officials while going it. I'm not too sure. At least going by the code, I found nothing. At least going by Companies Act, I found nothing. So this is something that
no, the NCLT can't be asked to do this. Yes. IBBI
due to inaction, due to inaction of RP in this regard, FC Bank of India had to file an IA before adjudicating authority, and just to counter that, landowners also filed another IA. Now, if the landowners are filing another IA, is RP responsible for it?
Not at all.
So how does this becomes a material for a finding against the RP? So this is a situation where first you are expecting the RP to travel beyond the contours of the statute, and second you are holding him for inaction for not doing so.
So both ways you reprimand him.
Both ways you are reprimanded, and now someone else is filing an application there, you are holding the RP guilty even for that as well.
Oh yeah.
So in spite of the objections, in spite of the objection raised by FC Bank of India with respect of treating landowners as home bias, not doing proper due diligence, and not revising the claim points to a malafide on the part of RP. Now, if I am a claimant, I am an agree with something, I raise an objection. RP, in his own wisdom or basis legal opinion, says that, sir, I feel that what you are saying is wrong. If you are agree, you please go to NCLT. That is what the mandate of section 60 subsection 5 is. What's wrong in that?
In fact, that has been allowed, right? That's like an omnibus provision.
Exactly.
Whatever is not mentioned, because you can't possibly think of everything that will happen.
Exactly, and the RP cannot favor any particular member to be in the COC. This
He
is
has
this
to
is
go as per verification of claims and what
exactly
is permissible, not permissible.
exactly. So he's saying that, sir, I cannot discriminate between you and other members of the COC. If you are aggrieved out of something,
Okay.
please go to NCLT, and I'll act as per the directions of adjudicating authority.
That is how it should be.
He is, and that's how it should be. He's bowing his head before the authority of NCLT. He is bowing his head before the Bank of India. He is bowing his head before the code.
True.
Now, coming to the next para, it is pertinent to note that the said 6 landowners had not contributed any amount towards the development of the project, and on the contrary, they had received security deposit of rupees 1.75 crore from the builder. Considering this fact alone, RP should have treated the landowners as home buyers and should not have given them any voting rights. The home buyers usually pay money to the builder for completion of a real estate project, and the builder does not pay any security deposit to the home buyers. Accepting the claim of the landowners as home buyers is a gross contravention of the code and regulations made thereunder. For argument, I concede even if this finding is right.
Right.
The first question is whether this finding or this thing will be held against the RP. Was that a subject matter of the show cause notice? That's the first question. If this is not, then natural justice has got violated because the RP has had never any opportunity to contest that. And before proceeding ahead, I must disclose that I do not know Mr. Vishal Jain personally. I'm just reading the order.
That's true. Neither one of us knows him personally. We are only trying to analyze this judgment.
We are just exactly,
Yes.
and only what is finding. And this thing is, and the order is not saying that this was part of that show cause notice or
Yes.
it was a ground for show cause notice. And personally, I have not seen the show cause notice as well. But I'm assuming that if this was not a ground in the show cause notice, certainly that order has traveled beyond the contours of the show cause notice. And there are laws that to that extent the order is illegal. Sorry, if it's the word used is not illegal, it is said without jurisdiction.
Without jurisdiction. Right.
A co-joint reading of the above extracts from the order suggests that the ground on which the contraventions of by Shri Vishal Jain has been established is only because in his wisdom it was chosen to rely on legal opinion. And that's what the entitlement of an RP is.
Yes.
When he's confronted with a situation, he analyzes it. He felt that I should go what the law says, and I'm not an advocate, so let me go for a legal opinion. I don't find there is anything is wrong.
No, absolutely. We all have to go to the expert in a particular domain if we're not experts in everything.
Now, if the legal opinion, and I'm assuming if the legal opinion said that no, you don't need to go to RERA registration, he has relied upon it. He may be wrong,
Absolutely.
but you cannot blame him from being negligent or rather malafide on that count.
That's right.
And that's what section 233 of IBC says. Now I'll open and read the exact words of section 233.
Perhaps you reproduced it here, or this is not.
I have extracted it. I have extracted it. I'll read the extract word. Yeah. Protection of action taken in good faith. The word is very succinct there. Protection of action taken in good faith. No suit, prosecution, or other legal proceeding shall lie against the government or any officer of the government or the chairperson, member, officer, or other employee of the board, or an insolvency professional, or liquidator for anything which is in done or intended to be done in good faith under this code or the rules or regulations made thereunder. Now, this aspect is very important. In para 4.21 of that order, this part is nowhere saying that which rule or regulation have I violated.
Exactly. They've not even mentioned that.
I may be wrong in my decision, but you cannot blame me for not acting in good faith.
True.
Catena of rulings have held that good faith indicates due care and precaution. I have taken a precaution to take a legal opinion. So even if I am wrong, the protection of action taken in good faith is acting in favor of me.
That's right.
So how am I to be held guilty on grounds of mala on that? And how have I not done proper due diligence?
That needs to be clarified, or you need to give why.
So, as I said, the good faith, I have also highlighted that Honorable Supreme Court ruling where they have used the General Clauses Act, and they say that, and the ruling says in para 22 in Gunda Venkateswaralu versus State of Andhra Pradesh, good faith, according to the definition in the General Clauses Act, means a thing which is in fact done honestly, whether it is done negligently or not. And my honesty is there when I have taken the legal opinion.
Right.
And ordinary prudence is not defined in good faith. That's very important to indicate.
Correct.
So neither in the code there is something ordinary prudence, neither the case law is saying ordinary prudence.
Ordinary prudence. And
I am being held guilty of malafide on grounds that ordinary prudence.
That's right.
So this is something which IBBI needs to look at, that how the order is traveling beyond the contours of the statute.
That's right.
Now, this is very important. One of the functions of IBBI, as has been stated in section 196, subsection 1, subsection D of IBC, is to specify by regulations standards for functioning of insolvency professional agencies, insolvency professionals, and information utilities. So my question to IBBI officials is, sir, if for a real estate project, if verifying the RERA details is such a requirement of law, why it is not featuring in the regulations as per the mandate of statute in section 196 1D?
True.
You are incorporating something ordinary prudence, that is something alludes to the words that is being used in IBC.
That's right.
But what is required in IBC, the code, the regulation is silent in it. And I am being held responsible for it.
Yes, I guess.
I mean, Mr. Vishal Jain is
yes, certainly. We understand.
Responsible for it. This is the problem that I'm trying to indicate.
Right.
The words standard has been quite succinctly used by the legislature in section 196 1D of IBC, and IBBI has nowhere framed any standard that in the CRP of a real estate project, RP must examine real registration details, as I said. So at least the charge of malafide that has been levied on Shri Vishal Jain, I think that is not
malafide is incorrect. I think perhaps maybe in defense of IBBI, I don't know. But whether one can identify and define everything. Some things are meant to be done by an individual. I am just giving a general view. I am not for or against.
But the point, what I'm trying to highlight,
every little thing may not be, be specified.
At least don't hold the RP guilty for it.
RP, and don't say it's malafide. Because, I don't see any malafide in this, but nonetheless, we don't know the background which is coming over here. But on the face of it, this seems so.
Rather, this situation should have been a ground to have a consultation paper opened that, look, this is what the situation I'm getting faced with. And I need opinions how this is to be tackled with. I feel that not verifying RERA registration details is wrong, but there is no law which is making an obligation to verify RERA registration details. So what is to be done in such situation?
Possibly.
I personally feel that this should have been the true course of proceedings, and this is how consultations are done.
Yes. Absolutely.
Suspension on this ground, I don't think it is. I personally feel it is violating the protection that has been given under IBC under section 233. So there, going further in the article, I have analyzed this part, the substance that I have
Yes.
told. To put succinctly, RP cannot be blamed for not being honest. This is the word honesty is very important. Now, how my honesty can be ascertained? Whether I have acted in conformity with the settled law or not.
That's true.
What else is the parameter to define honesty? The law is not making any prohibition in terms of taking a legal opinion. In terms of, and also it is the practice of many, on many occasions, it is the practice of public sector undertakings to take a legal opinion. So if I am following an industry practice to deal with a certain situation, how am I not being honest?
That is something IBBI needs to answer. They have, but they really haven't.
So this is something IBBI officials need to think through it.
Think about it, yes.
Now, as I said earlier, that Shri Vishal Jain has been held in the wrong footing for not approaching the adjudicating authority for guidance. I mean, it's a settled position of law, as maybe Katina of rulings have said. I have just cited one ruling of Ayub Khan Nur Khan Pathan versus State of Maharashtra, which says that only a person who has suffered an injury or suffers from legal injury can challenge the action, order, etc. in a court of law.
That's
For Bank of India to approach the honorable adjudicating authority, it's quite understandable, because their share in the voting share in the COC is getting reduced.
Yes.
For them to be agreed, it's quite understandable. What will Shri Vishal Jain says? That I have a problem that Bank of India is not getting a certain percentage of voting in the COC. And if this is not favoring a particular member of COC, what else is?
That's right.
So here, going further down the article, I have analyzed that. In fact, the impartiality of Shri Vishal Jain is being held against him in this case. And begetting unnecessary litigations, that was a word that was used in that part of order.
No, I
unnecessary litigation. I mean, if there, so what purpose will section 60 subsection 5 solve? If RP is the decision maker of interpretation of law, then maybe
we don't need NCLT then.
We don't need NCLT. Section C subsection section 60 subsection 5 is rendered OTOs. It is not serving any purpose. The only easy way is that if you are aggrieved, you file a complaint with IBBI. IBBI will take the rest of care of it.
No, so that's very convenient, right? If you don't think something is as per what I think it should be, I'll go and complain against the RP to IBBI, and then IBBI should obviously take some action. So a lot of complaints are frivolous. I'm not pointing to this one because, like we said, we are not, pinpointing or doing anything of the sort. But yes, many applications are frivolous, and it is for IBBI to go through each one of them and see the merits of each one.
In fact, I'm not sure about the regulation, but I think in the complaints and grievance regulations, there is a provision which says that IBBI needs to look through it, that whether the complaint is maintainable or not. I think I'm not
Absolutely.
too sure.
It has to be so. I think, but I'm not sure either.
I'll check through and confirm the exact provision. Yes. So referring to next contravention, yes. Reduction in notice period for the 8th COC meeting. Para 5.6. On perusal of, I'm sorry.
That's okay.
On perusal of the record, it is noted that the Bank of India, being applicant to the IA bearing number 1035 of 2021, had shared the copy of order dated 8 September 2021 with the RP on 14th September 2021 at 11:40, wherein adjudicating authority has directed to reconstitute the COC and convene the meeting within a week from the date of the order. The RP must have remained present when the direction was issued by adjudicating authority.
Assumption.
So if the honorable member says that whether the application is allowed or disallowed, RP should have remained present to see that as well. But still, it is understandable that when an understandable, but if the bench pronounced only the operative part, what else could the RP have done?
That is something I think they don't realize, that it's only one line, ideally, or 2, 3 lines that they read, as you said, the operative part. So we don't know the context behind that until you get the physical copy of the order or when it is uploaded first. So
I think there is also a case law which says that until and unless the order is ready, it should not be pronounced, because what that does is that if, for example, and I'm digressing a bit from here, if there is a demolition case and if a pronouncement is made that look, I'm dismissing this application against demolition, and very next moment the corporation authorities come up in front of your building that let's demolish it, you have lost that opportunity to file an appeal against that order because you're not having the order copy of that.
correct.
So this was a case that was discussed by the Honorable Supreme Court in one of the matters, and therein the Supreme Court was very categorical in terms of saying that, look, until and unless you are not ready with that order, please do not pronounce it.
True.
So I'm not right now recollecting that the name of that ruling, but yes, there is such an order which is existing. Anyways, coming back to this, hence, instead of waiting for that order to be communicated from Bank of India, RP should have proceeded to convene meeting of COC by giving minimum time as stipulated in Regulation 19 of CRP regulations. Now, this is very important. The manner in which the orders are pronounced in open court are to be communicated to the parties is quite succinctly laid out in NCLT rules.
That's right.
Rule 150 of NCLT rules says, I'm skipping certain part. I'm just reading out the rule 3.
Yes.
A certified copy of every order passed by the tribunal shall be given to the parties. So NCLT rules itself is saying that, look, even if an order is passed, even it is orally pronounced, you have a right to obtain a certified copy of that order. So at least the mandatory requirement to remain present and act basis what has been pronounced, at least that is not coming out from Rule 150 of NCLT
Right.
rules. Second is, every order or judgment or notice shall bear the seal of the tribunal.
That's right.
At least in NCLT Mumbai, I have not seen that there is a practice of there itself issuing a dasti copy,
No.
bearing the seal.
No.
It's they pronounce, then you wait for that order to get uploaded, you file a certified copy, and basis the certified copy, you act accordingly.
In fact,
This is what the practice of NCLT is.
Yeah, at least in Bombay, so many times we've seen that it's pronounced and still not uploaded even for days together, even after pronouncement.
So at least the ground that is being held against Shri Vishal Jain, that the moment it was pronounced, he should have acted as per regulation. I think IBBI needs to relook that.
Yeah, unless and until a person at a party has a copy of the order in his hands,
certainly acting,
it will be difficult to act. You don't know what are the contents of the order. How can we presume?
And this thing has already been settled by Honorable Bombay High Court. And the order of Bombay High Court is uploaded in IBBI website itself.
Right.
Where the principles of, as stated in Rule 150 of NCLT rules, they had been upheld. And the Bombay High Court was very categorical that, sir, even if you're acting under IBC, you have to follow this law. Right. So I have quoted the extracts of the Bombay High Court ruling. It says, Sub-Rule 3 of Rule 150 says that a certified copy of every order passed by the tribunal shall be given to parties. And then Sub-Rule 4 says the tribunal may transmit the order made by it to any court for enforcement on application made by either parties to the order or suo motu. So the mode of communication of that order is not getting restricted to what has been pronounced, but it is also saying that the communication has to be made, and it says that either on the application or suo motu. So at least acting by remaining present is not a mandatory requirement of law.
That's true.
If there is apps, now this was in a different context, but there says that rule for 151 has been inserted with a purpose. Now coming to rule 157 of NCLT rules. Transmission of order by the court master. The obligation has been placed on the court master. I'm reading the sub-rule 3. The deputy registrar shall thereafter cause to transmit the case file and the order to the registry for taking steps to prepare copies and their communication to the parties.
That's right.
So the mode of communication to the parties is not just pronouncement of orders, but also the communication made by the NCLT registry. So even till the time Shri Vishal Jain was not having the copy of that order, he had no obligation to act on it.
That's true. So it's essentially over here, for the benefit of those who are not reading this and just listening to this. It is that the transmission of the order will first be from the court master to the deputy registrar, and then of course from the deputy registrar to the registry, and then from the registry to the parties concerned. So there is a process flow. I mean,
there is a process flow.
Yes.
Now, para 81 of Kamal K. Singh versus Union of India. The requirement of making entries by court master would play a very vital role in the conduct of judicial proceeding as contemplated in Rule 156 and 157. There is a transmission of order by the court master.
True.
And this right has been decided by the Honorable Bombay High Court. A communication of the order to the parties is contemplated by sub-rule 3 of Rule 157, but after that is pronounced by the bench.
After that is pronounced, and I think that is what is important also.
After pronouncement, there has to be a communication of the order to the parties, and RP was entitled to
and not at the time that he should have been present at
present and acted as per that. And there has been no challenge to this order as yet.
Okay. So this stands.
A cogent reading of Rule 150 and Rule 157 of NCLT rules suggests, as has been reaffirmed by Honorable Bombay High Court in Kamal K. Singh's case, is that the obligation to communicate the order passed by Honorable NCLT is on the tribunal, and the order has to bear the seal of the tribunal. So it's not that suddenly I can say that, look, I have heard the order. Now you have to comply with the order. Now I am standing at the doorstep of you. Please comply, else you are guilty of contempt. So sorry, that was not contemplated in NCLT. And exactly this is what the practice Kamal K. Singh stopped. The ruling of Kamal K. Singh stopped.
Yes.
Therefore, expecting the RP to remain present when such direction was issued by the Honorable Adjudicating Authority and holding him guilty of wrongdoing for not doing so is not only placing additional obligations on the RP beyond the statutory requirements of law, but also contemptuously disregards the intent and spirit of Rule 150 read with Rule 157 of NCLT rules and the procedural mandate consecrated by the Honorable Bombay High Court in Kamal K. Singh's case, which governs how and when a pronouncement made by the Honorable NCLT is to be recognized as an order.
That's true.
Now, coming to the for paragraph 4.8 of that order, the sincerity to follow and pay deference to the Honorable NCLT's order is evident from paragraph 4.8 of the order, where Shri Vishal Jain took steps to comply with that Honorable Tribunal's order the moment he was communicated about the same. The Bank of India communicated about it that, look, sir, there is an order, you need to convene a meeting by this day, and he has acted according to that.
Yes.
So he is complying with the principles of Bombay High Court ruling. He is respecting Honorable NCLT. The least that is expected is the protection governing under section 233 of IBC should come to his rescue. Else, what is the protection serving?
That's right.
Now, as I had stated, section 196(1)(d), it was the obligation on the on the IBBI
IBBI.
officials to frame appropriate
Standards.
regulations.
Yes.
I mean, if they did not do their part as provided in the statute, certainly now Vishal Jain is being held guilty for it. I'm skipping this part because
Yes.
it's actually a fact, but an unfortunate fact. Man, this order is featuring in IBBI website, and if they do not read that and act as per that, I mean, something which is IBBI needs to get its act together.
Absolutely.
Now, contravention 6, appointing ex-partner and prospective resolution applicant to manage day-to-day affairs. Now, findings of IBBI in that part I have reproduced. Para 8.6, irrespective of the fact that as per direction of the COC, suspended director was appointed as industry expert, despite Mr. Ankit Wadhwa being the prospective resolution applicant and thereby passing the day-to-day responsibilities to him, is clear contravention of section 25 subsection 1, which directs that the owners of preserving the value of assets on the CD, including continued business operation, rests with the RP. Now, section 196 says that how the RP is to operate, the obligation of setting the standard is on IBBI. Sir, if you have not set that standard, my COC says, and I am in concurrence with it, that, and he is an expert on that domain. I find him as an expert. What wrong have I done by appointing him? Which part of the code prohibits from me doing so?
Absolutely.
Which part of the code says that no, it is you who have to remain there? The manner in which I protect my asset, that has been given to me. The decision has been given to me. And as far as there is not a destruction of that asset, sir, I am entitled to the protection under section 233 of IPC. Yes, if there are certain complaints that are coming that look, there is the assets are going, sir, you please take care of it. And if I do not act as per it, then that's a different thing. But here my COC is in concurrence with my decision. So what wrong have I done?
No.
And as I started initially, if this is dereliction on duty on their part, I'm sorry. The bank officials had no opportunity to contest that.
That's true.
So I think if this order becomes a precedent, I don't think the COC members will take any decision, any tough decision, and that too in front of a hostile management.
Anyway, they take a very long time to take decisions. This will only add fuel to fire. This will only make it worse.
This is just adding to the problems. COC can't hide behind commercial wisdom to justify its decision to appoint Mr. Wadhwa as industry expert, knowing fully well that a prospective resolution applicant, he could leverage the information related to CD to his advantage and avail undue competitive advantage. Similarly, RP is in no position to hide behind the erroneous mandate of COC, as this action was not tenable as per statute and he was needed to resist it earnestly. So my question to the IBBI officials is that, sir, have you set any regulation governing the code of conduct for the committee of creditors? The answer is, as on date, it is no. So if you have not cast any particular duty on the COC members, how is that a dereliction of duty? And what is the erroneous mandate in it? Which part of law has been violated?
That's true.
Now, I have quoted the extracts of section 19 of IBC.
Exactly.
Personnel to extend cooperation to the interim resolution professional. The personnel of the corporate debtor, its promoters, or any other person associated with the management of the corporate debtor shall extend all assistance and cooperation to the interim resolution professional as may be required by him in managing the affairs of the corporate debtor. The word is very succinct, as may be required by him. If I am appointing someone who I feel is the best person to do that job and I require him for that services, the mandate by the legislature has been cast upon me to make such decision.
Not only that, I think IBBI should realize that I am an outsider. I have no clue how the company is being run. If I obviously will rely upon the existing promoters or the management to help me and cooperate with how to run this business, unless of course I want to come and shut it down, which is not the intention, because you have to keep it as a going concern. So you're arguing against yourself when you say this. On the one hand, you're saying Section 19, I will seek cooperation, and then on the other hand, you're saying, well, they shouldn't have done it.
Achha, one part I missed while going so. When we are starting, I had said that at times I feel that IBBI travels
beyond the scope,
beyond the material on record. Now, reading by that order, I couldn't find any material on record as narrated in the order by which a conclusion can be drawn that he actually did leverage the information, or rather he was in a position to leverage that information. We don't know whether proper safeguards has been there or not.
See,
we don't know that.
I, of course, don't know under what context, in what context this is being said. But if he's not prevented under disqualified under 29A, okay, then he's going to have this advantage always. I mean, what can you do about it?
And legislature, in its wisdom, has contemplated this. Whether a legislature is right, legislature is wrong, that's a different story. And at least IBBI is not an authority to decide that. And material on record do not suggest anything along this line. At least what has been reproduced in the IBBI order. At least I couldn't find it. Hence, I say that at times maybe IBBI travels beyond what is material on record, going by what they reproduced.
Correct.
So now coming back, the words used by the legislature is quite succinct. Cooperation to interim resolution professional as may be required by him. Hence, the decision on the manner in which the cooperation is required is within the meaning of Section 19 of IBC, is vested by the legislature with the IRP/RP, and legislature nowhere has circumscribed the exercise of powers of Section 19(1) in IBC in any manner to ensure a level playing field. And so if ensuring a level playing field was the mandate, it should have come by the regulations. So there's no question of hiding behind anything when the action is in strict conformity to the governing provisions of the statute and has the concurrence of COC. It's a rare occasion, but it's a welcome occasion in which the COC and the RP is on board regarding protection of assets. Therefore, holding Shri Vishal Jain guilty of dismantling the level playing field available to the prospective resolution applicants in para 8.1 of the order insinuates the RP for an offense that was never the intent of legislature. Therefore, such a charge in para 8.6 of the order exhibits a contemptuous disregard for the principles of interpretation of statutes by IBBI officials, which have been settled by honorable constitutional courts in a catena of decisions. I have reproduced one. The scope of the legislation on the intention of legislature cannot be enlarged when the language of the provision is plain and unambiguous, and statutory enactments must ordinarily be construed according to its plain meaning, and no words shall be added or altered or modified. Level playing field ensuring is not a part of Section 19 of IBC. So IBBI officials could not have added any additional words to that. Now, in the event of any modification, at least IBBI is not an authority to it. At best, an interpretation can be made a reference to the Honorable Constitutional Court. The constitutionality of that can be challenged, but when there is no restriction on me, I think holding me guilty for availing that benefit, I think is traveling beyond the law. Now, yes, other resolution applicants may say that my equity has got violated because the prospective resolution applicant, one person had the benefit of availing all information, maybe more than what he had. But the thing is that since he was in the management of the company, even before initiation of CIRP, he was having that benefit.
Yes. You can't take it away.
And legislature in its conscious wisdom has given him that chance. So even the legislature has dismantled the level playing field. As per if the understanding of IBBI goes. If that's the case, if that's the law, then so be it. Principles of equity cannot be applied while considering the provisions of the code. That's what the settled law is. Holding me guilty for that is wrong. Me means Shri Vishal Jain. Yes, here I have also my apprehension that whether dismantling the level playing field available to the other prospective resolution applicants was the subject matter of show cause notice. In case it was not, then Honorable Supreme Court in UMC Technologies versus Food Corporation of India has ruled that any order traveling beyond the bounds of notice is impermissible and without jurisdiction to that extent. Right. I have reproduced para 13 of that order. I'll read the highlighted part. The basic principle of natural justice is that before adjudication starts, the authority concerned should give to the affected party a notice of the case against him so that he can defend himself. Such notice should be adequate on the grounds necessitating action, and the penalty stroke action proposed should be mentioned specifically and unambiguously. So if dismantling the level playing field was a ground, it ought to have been mentioned in the show cause notice unambiguously. An order traveling beyond the bounds of notice is impermissible and without jurisdiction to that extent. This is what the law of the Honorable Supreme Court has settled. Further, it is essential for the notice to specify the particular grounds on the basis of which an action is proposed to be taken so as to enable the noticee to answer the case against him. If these conditions are not satisfied, the person cannot be said to have been granted any reasonable opportunity to have been heard. Correct. So this part should have been very categorically mentioned in the show cause notice that, sir, by appointing an the personnel of the corporator, sir, you are dismantling the level playing field available to other prospective resolution applicants. If it was not mentioned in the show cause notice, the finding is beyond the jurisdiction. That's right. And in case IBBI feels that dismantling the level playing field is something that should be plugged, the mandate is already there. It is for the IBBI to set appropriate regulations for it. Sure. If IBBI has not placed any appropriate regulations, I'm sorry, Shri Vishal Jain cannot be blamed for that. Intervention 7, non-verification of claims of the home buyers. It is not a disputed fact that the claim has not been cross-verified by the RP. As a part of due diligence, the RP should have cross-checked the claim received from home buyers. As per loan agreement, the amount was to be routed through escrow account. The plea taken by the RP that he is not being required to check whether or not proceeds received from home buyers are routed through escrow account cannot be accepted. My question to IBBI officials are, sir, why can't it not be expected? Why can't it not be accepted? No. If the mandatory requirement of law says that you need to also check the route of through which the money is being channelized, sir, which part of the regulations mandates this? And moreover, catena of Supreme Court rulings, catena of Honorable Enclave rulings, catena of NCLT rulings have said that balance verification through balance sheet is a requirement of law to ascertain that whether a debt is there in the books of the corporate debtor is not. Now, I'm not too sure that whether this is the case here, but at least the sanctity of a balance sheet, that is getting diminished. If I start looking also that how the money got routed. I have received a certain amount. If there is there in the books of the corporate debtor, if it is featuring in the balance sheet, I'm quite entitled to accept that claim. Else the claimant can very well approach the NCLT and say that, look, despite the law says that the balance sheet is a good enough proof for admission of my claim. The RP is not accepting it because I have not routed through a particular channel. Sir, IBBI, the RP is acting in contempt to the settled position of law. What would have I answered? And NCLT would have asked that which regulation asks you to do it, to check the root of the transaction. When Katinoff rulings have said that balance sheet is a good enough proof.
Absolutely.
Now, Regulation 13 of IBBI regulations that I have cited here is pertaining to the process of verification of claim. No part of that says that I also need to check the root of the channelization of money, as is being done in this case. So I think I cannot be blamed for that.
Right.
Now, the forms that has been provided in the IBBI Schedule 1, even that is not having any field that I have to also disclose the route through which this channelization was done. So holding me guilty on that count, I think traveling much beyond what even the regulations are saying and certainly what the code is saying. Rather, it is expecting something which is perhaps going in contempt to the settled position of law. So Shri Vishal Jain is correct that there is no requirement of in law to verify the root of transfer of the amount in lieu of any financial credit. And going ahead, if in case there was, the obligation was on IBBI officials to frame appropriate regulation.
Okay.
Okay, this is the start that we discussed earlier, not providing supporting documents with the COC meeting notices. The DC notes that if there is any confusion in the mind of RP as to which, no, sorry, this we have not discussed, sorry. This is the ground that if the investigation authority or the inspecting authority needs more documents, then the adjudicating authority, the RP needs to provide that. And RP also needs to check up that, sir, do you need more documents? So it is the obligation that has been casted on the RP.
Right.
So para 10.5, the DC notes that if there is any confusion in the mind of RP as to which document IA is asking, he should have contacted IA and sought clarification instead of not submitting reply on the ground that it was not clear which documents are sought. So this is one of the grounds for which Shri Vishal Jain has been held on the wrong footing. Now this is very important. The language used in Regulation 4, Sub-Regulation 4 of IBBI Inspection and Investigation Regulation is quite succinct in terms that a service provider has to provide such statements and information relating to its activities within the time as inspecting authority may require. So inspecting authority has to convey its requirement. I mean, the RP cannot be left guessing as to what you require. And if this is the precedent, then I'm sorry, we are apprehending a situation where anyone who's facing investigation against his conduct, every morning the RP has to call to IBBI and say that, sir, today morning, do you need any document? Because that's what is falling from this part of that order.
Yes.
I mean, hundreds of calls are getting bombarded in IBBI office every morning. IBBI officials are saying, RPs are saying, sir, do you need any document?
No, which is why they've already framed, right? All the forms that need to be filed periodically. They've already stated what they need.
I mean, maybe my presentation is something which is traveling beyond what is acceptable. But the thing is that that's what the situation.
No, that is likely what, I mean, that is implied, right? That this is otherwise how you would want, it would have to proceed.
So it's the obligation has been there in the regulations on the inspecting authority on what you require.
Right.
Certainly contacting the IA is something which is traveling beyond the regulations. Therefore, as evident from the above extracts of the para 10.5 of the order, there has not been a dereliction on duty on the part of there has not only been dereliction on duty on the part of IBBI IBBI officials in terms of conveying the requirements to Shri Vishal Jain in terms of Regulation 4, Sub-Regulation 4 of IBBI Inspection and Investigation Regulations, but also has been an attempt to pin the fault on Vishal Jain.
Right.
So this is how we are. Now, okay, this is not the first time that such orders IBBI has passed.
Mhm.
So this has been there earlier as well. So when the RPs are dealing with the situation, such situation, what are the remedies available to them?
Right.
That I had discussed in one of my previous articles when I had analyzed the disciplinary committee findings in the matter of Shri Yogesh Kumar Gupta. I'll open it, we'll go through it. So this was about a year back, and I had analyzed the regulations prevailing then. That prior to issuance of show cause notice, certain procedural safeguards in place in the resolution in the IBBI regulations itself. Regulation 7.3 of IBBI grievance and complaint handling procedure, disposal of complaint. This that I was referring to. The board shall form an opinion whether there exists a prima facie case within 45 days of receipt of the complaint.
Correct.
So it is the board
that maintainability that we had spoken about.
That the maintainability that we had spoken.
Yes.
The case laws, the court rulings are there in the very IBBI website themselves. Only thing that is required to be done is to read them and ascertain that whether the complaint is maintainable as per the settled position of law. Else, what else is this procedural safeguard doing? The second regulation that I'm referring to is Regulation 10 of IBBI Inspection and Investigation Regulations. The investigating authority shall submit the investigation report to the board. The board shall examine the investigation report as to whether investigation is complete and satisfactory or it requires further investigation, and advise the investigating authority accordingly within the 15 days of receipt of the investigation report. Now, the last part that we discussed in Shri Vishal Jain's order is that if the investigating authority had not intimated its requirements, that it needs further documents as per Regulation 4, Sub-Regulation 4, then how can the investigation be complete?
Correct.
And that is, I'm sorry to say, but prima facie what it appears is that there is an attempt to cover up that maybe negligence, maybe shortcomings.
Oversight, yes.
Maybe shortcomings by saying that no, the RP should have contacted the investigating authority. So maybe an attempt to pin the blame for the fault on the part of IBBI officials. And unfortunate, but this is what emerges.
Possible. It is possible.
After taking into account advice of the board, the investigating authority shall prepare the investigation report and submit to the board. Now I'm reading Regulation 11, Sub-Regulation 2 of IBBI Inspection and Investigation Regulations. If the board, after consideration of the report under Sub-Regulation 1 and on basis of material otherwise available on record, is of prima facie opinion that sufficient cause exists to take such actions, there is one point important to be noted: material otherwise available on record. So you have to call for documents if you feel that there are certain shortcomings. Certainly, the RP cannot sit here and have left guessing.
Yes, that's true.
And it shall issue a show cause notice in accordance with Regulation 12 to the service provider or an associated person, and in any other case, close the investigation or close the inspection or investigation as the case may be. Regulation 12.2. For the purposes of Clause E of Sub-Regulation 1, the board shall take into account, but not limited to, the following factors. The very first part in Sub-Regulation B, the consequences and impact of the alleged contravention. Nowhere in the order of Shri Vishal Jain says that how did Shri Vishal Jain benefited out of out of the alleged malafide or misconduct.
That's true.
Nowhere in that order, but that is a mandatory requirement of law that has to be taken into account. So if that has not been taken, and even if it is that taken into account, and that is not finding a mention in the IBBI order, then certainly all the materials have not been reproduced. At least what is a mandatory requirement of law, that is not reproduced. So how can someone contest that part?
Yes.
Now, though the IBBI regulations do not explicitly specify the mandatory requirement of supplying the noticee against whom disciplinary action is proposed to be taken with the copies of opinions, reports, documents prepared in compliance with the aforesaid regulations, but if an action is sought to be taken, the position in law settled by the Honorable Supreme Court casts a duty to provide the same prior to any disciplinary action. I have narrated the Honorable Supreme Court rulings here. The first ruling that I'm referring to is Kashinath Dikshita versus Union of India, Para 10. No one facing a departmental inquiry can effectively meet the charges unless the copies of the relevant statements and documents to be used against him are made available to him. It is difficult to comprehend. I have in this extract, I have skipped certain part and I'm reading the going a bit ahead. It is difficult to comprehend why the disciplinary authority assumed an intransigent posture and refused to furnish the copies, notwithstanding the specific request made by the appellant. It is in the case of Kashinath Dikshita, made by the appellant in this behalf. Perhaps the disciplinary authority made it a prestige issue. If only the disciplinary authority had asked itself the question, what is the harm in making available the material, and weighed the pros and cons, the disciplinary authority could not have reasonably adopted such a rigid and adamant attitude. Now, this is the language that Honorable Supreme Court has used.
Right.
If the noticee, if someone who's facing a disciplinary inquiry is not being provided with the entire material on record. So if I'm facing a disciplinary proceeding, it is within my right to ask for every material, every scratch of T, every dot of I, which is being held against me.
That's right.
And if that is not being provided to it, then certainly it's a contemptuous disregard of the law settled by the Honorable Supreme Court. And rather, these rulings should find a place in terms of the regulation as well.
Yes, absolutely. Because it's unfair, right? If you don't make everything available and then you proceed to.
Quite unfair. Now, this is State of UP versus Raj Narayan. In a government of responsibility like ours, where all agents of the public must be responsible for their conduct, but there can be but few secrets. The people of this country have a right to know every public act, everything that is done in a public way by their public functionaries, and they are entitled to know the particulars of every public transaction in all its bearing.
Right.
And here I am fighting about my rights. The responsibility of officials to explain and justify their acts is the chief safeguard against oppression and corruption.
Yes.
So why are these rulings are not finding a place in IBBI regulations? I have IBBI regulations, IBBI officials must think through it. That's what I feel. Because these are important procedural safeguards which even a common man has, and I am an officer of the court. I means the RP is an officer of the court.
Yes.
It is not only the right to receive the documents that have been provided, but also a professional duty, but also the professional facing disciplinary action has been conferred the right to test the evidence adduced against him by way of cross-examination. If a report is being made against me, certainly I have the right to cross-examine the person who is making a report.
Right.
It's like, for example, if someone is in jail, the police in that investigating officer is made to appear before the magistrate.
Right.
Especially in cases of bail application. That's what do you have to say? So the same parity is there even in terms of the disciplinary proceedings as well. Para 6, State of Assam versus Bimal Kumar Pandit. An inquiry must be conducted according to the rules prescribed in that behalf and consistently with the requirements of the natural justice. At this inquiry, the public officer concerned would be entitled to test the evidence adduced against him by cross-examination where necessary to lead his own evidence. Now, had I been Mr. Vishal Jain at that point of time, I would have asked a question that, sir, basis what are you coming to the conclusion that the level playing field is getting disturbed? I would have requested cross-examination on this very count, because that is being held against me. It's not that I'm being alleged that I have violated so and so provision, and that's what the entitlement section 19 has given to me, and my COC is in concurrence with that. So if as per the opinion of IBBI officials it is a erroneous mandate, I have it is my right to cross-examine them that how is it an erroneous mandate when the regulations are silent in it. Then the second ruling, Rajiv Arora versus Union of India, para 13. Effective cross-examination could have been done as regards to the correctness of otherwise of the report if the contents of them were proved. The principles analogous to the provisions of the Evidence Act and also the principles of natural justice demand that the maker of the report should be examined. So if the investigating authority is making a report against me, I have a right to examine them. That what is the material that is being used against me to arrive at such a conclusion?
Yes, absolutely. That's only fair.
And this is the last ruling that I have referred. Maninderjit Singh Bitta was the Union of India. Every person is required to respect and obey the orders of the court with due dignity for institution. The government departments are no exception to it. Certainly, orders of the court also means that the ratio that is flowing for the honorable constitutional court rulings. So it's not that they can claim such privilege. No, I'm acting in good faith, so you cannot cross-examine me. Sorry, that is the law. And that's my right, which the Honorable Supreme Court has settled. Agreed, it is not pertaining to the disciplinary proceedings of IBBI, but the ratio of that is binding.
Yes.
It's not that any exceptions has been provided.
That's
you
true.
are a public officer, you are a government department. There are certain procedural mandates that you have to follow. There are rules. There are statutory provisions within which you have to act. But if I feel that you are transgressing it, I have to cross-examine you to ascertain the basis on which you are arriving at such a conclusion, because my right to practice is at stake.
That's right. So great. So I just hope, due credence is given to this, because we have observed this, that like I said at the beginning, that the RP appears to become a scapegoat for everyone, not just IBBI, every person.
So the intent of this discussion was not to defend Shri Vishal Jain,
and not to demean IBBI either.
IBBI officials.
It's just a very neutral, objective way of looking at things, which we feel some things are amiss.
And personally, I do not know him. But I felt that this order is setting a wrong precedent, not only for Shri Vishal Jain, but
for
also
all
the
RPs
bank officials.
And the bank officials.
For all RPs and even the bank officials involved.
Yes.
I mean, at the end of the day, if they take out the report, they are facing an inquiry. And we know how inquiries go.
Yes. Yes.
And at the end of the day, what will happen is, which Bank of India official will take the risk of having Shri Vishal Jain in a particular CIRP project?
Yes, this has a professional, there is a stigma attached to all this. It will have there are consequences which will flow from this, whether one likes it or not.
And the problem is that no one had any opportunity to contest it.
That's true.
And I'm not too sure, but had I been in this person, I would have made a communication to the Indian Bankers Association and also the Bank of India and saying that, sir, this though there is an order that is operating, that is making a reference to you, but I must point out that the Bank of India officials had no opportunity to contest that, at least not flowing from what is there.
Correct.
And IBBI is not having any jurisdiction to form any opinion on that.
That's true.
The show cause this order is arriving um, as a consequence of the show cause notice,
Hmm.
and the show cause notice concerns me. I am contesting it as per my merits. They have nothing to do about it, and it's not that I'm trying to favor someone. It is what the law is.
Right. Very true. Very true.
So
So,
there are many case laws which I have further highlighted. But as far as protection to RP goes, I think this till Maninder bit that
hmm.
it can be used.
No, I'm sure your blog has given, there's a wealth of information there, which I think RPs will find very useful. And I hope this blog, I mean, is taken in the right spirit by people
Right. Right.
concerned, the officials concerned. So thank you, Pratik.
Thank
Thank you
you.
so much for this
Thank you.
conversation.
Thank you.
Thank you.
Bye.
Bye.